Hello, young lawyers. Every day, young lawyers come across people who say that, look, I had entered into an agreement to purchase this property for 50 lakh, 1 crore, whatever. Now the opposite party is resiling, it is not complying with, it is not selling, the party is not selling the property to me. So under these circumstances, you have to bring a suit for specific performance. Now the seller has to bring a suit for specific performance if he wants that that very property should be given to him at that very price. This is called a suit for specific performance. You know that in Hindi it is called Vinirdisht Anutosh. Now what happens, many times it is seen that during all this negotiation, when a party has entered into a compromise and the other party, seller, says, no, I am not going to sell it under these circumstances because there has been delay or there is some default on your part, so the contract of the sale agreement stands cancelled. So such a letter is many times given by the seller. What the letter says, that the sale agreement stands cancelled. Now, what relief the purchaser has got if he wants to purchase that very property? The purchaser will bring a suit for specific performance, all right. But what happens, many times it is seen, I have seen many cases up to the Supreme Court, where the lawyers do file a case for specific performance, but forget to make a prayer that the letter stating that the sale agreement to sell stands cancelled should be declared null and void. This relief of the cancellation letter, that the cancellation letter should be declared null and void, is not claimed by many lawyers in their suit for specific performance. Now if such a thing happens, then the suit will fail. Please, my dear advocate friends, make it very sure that if you have to bring a suit for specific performance on behalf of the purchaser and the seller has given a letter to the purchaser that the sale agreement stands cancelled because of this reason, because of delay or because of any other reason. So you have to make a prayer that the letter cancelling the sale agreement is null and void. It should be cancelled. Now, this objection, if you are agreeing for the seller, so, and you don't want to sell it, so you have to take this objection that, look, in the prayer clause, you have not made a prayer that the letter cancelling the sale agreement should be declared null and void. Now, if you do not make this objection, if you do not take this objection in the district court, if you do not take this objection in the high court, even in the Supreme Court, you can take this objection. Now, I will give you only two rulings. One is R. Kandasamy versus T.R.K. Saravathi, decided on 21st November 2024, reported in 2025, Volume 3, SCC 513. In this case, the High Court judgment reversed by the Supreme Court because a seller filed a SLP before the Supreme Court and said that you have not made a prayer for cancellation of the letter by which the sale agreement stood cancelled. Now let us read only two sentences, one of para 41, the other of para 45. Para 41, where the vendor unilaterally cancels an agreement for sale, the vendee who is seeking the specific performance of such agreement ought to seek declaratory relief to the effect that cancellation is bad and not binding on the vendee. Again in para 45 it says, should the trial court not satisfy itself that the jurisdictional fact for grant of relief does exist, nothing prevents the court higher in the hierarchy from so satisfying itself. Means if the objection has not been decided by the trial court or by the High Court, even the Supreme Court can decide it. The same issue has once again been reiterated by the Supreme Court in 2025 itself in a judgment dated 4th of April 2025, Sangeeta Sinha versus Bhavna Bhardwaj, 2025 SCC Online SC 723. Para 25, I'll read one sentence. Appellate court would not be precluded from examining whether the jurisdictional fact exists for grant of relief of specific performance, notwithstanding the fact that the trial court omitted or failed to frame an issue on maintainability of the suit. In para 27 it says, absence of a prayer for declaratory relief that termination/cancellation of agreement is bad in law will result in a suit for specific performance being not maintainable. So my dear young lawyers, please sit with seniors and learn the niceties of the law. Most important thing is that in every suit for specific performance, if you are appearing for the purchaser or for the seller, or you are interested in the specific performance of the agreement and the opposite party has given a letter saying that the agreement stands cancelled, then in the prayer clause of the plaint, you must make a prayer that this letter cancelling the sale agreement is null and void. Thank you.